This Free Market Foundation media briefing. My name is Jane Boccoleone. I'm the Media and Communications Manager here at the Free Market Foundation, and welcome to you all. Today's topic is the upgrading of Land Tenure Rights Act, known as ULTRA. The original act was in 1991, and the Free Market Foundation was intimately involved in bringing this about. The purpose was to convert a title to full ownership directly, no red tape and no procedure. We're having this topic today because at the moment there is an ULTRA amendment bill before Parliament. This is a very important bill. And I'd like to introduce my colleague, the Free Market Foundation founder and president, Leon Lowe, who's going to explain what this amendment bill is all about and why it is important to South Africans today. Leon.
Well, my pleasure to be with you, and I'm going to speak about some controversial issues here and make an apology for that. During the question and discussion time we can address them. The context in which this takes place is that we have the upgrading of Land Tenure Rights Act in South Africa being amended in Parliament right now to comply with a constitutional court order declaring Section 1 of the Act to be unconstitutional. This is actually probably South Africa's most important law, and yet ironically and strangely it's a law almost no one has heard of, whether in or out of government, whether affected by the Act or not. And saying that it is South Africa's most important law is obviously quite an extreme statement to make when it's unheard of and no one knows about it, so I have to obviously justify such an extreme statement. What makes it the most important law in South Africa that no one knows about is that it's the, I'm just going to backtrack on that last slide, that it basically converts all proclaimed land, now I won't go into the definition of that yet, but it is land proclaimed in areas where largely black people live, or historically black people, into full ownership. It declares black people to be owners of land they held under various forms of apartheid title and tenure, and nobody knows how many are affected by it. My own estimate, which is as good as anybody's, is about 4 million homes, or the home of something like 16 million people, if you assume 4 per home, have been converted in 1991 into full ownership. They are the owners, according to the upgrading of the Land Tenure Rights Act, ULTRA. And this is an extraordinary act of empowerment and ownership and reversal of South Africa's apartheid land laws, which were of course extremely obnoxious and said black people essentially could not own land anywhere in South Africa, including even in the so-called Bantustans or homelands, where they occupied land but did not own it. So this was meant to be drawing a line in the sand, putting that behind us and declaring all the people at least who had homes, and those homes could be registered because they were proclaimed in a township register, in the deeds registry, to be owners, and all it had to do to follow was that the deed had to be issued. So it created owners. It didn't say that they would in the future become owners, and when the title deeds are issued, that is not what makes them the owner. What makes them the owner is the Act itself. And I'm going to quote from the Act and from the Constitutional Court judgment to that effect. Now, what the ULTRA Amendment Act does, or bill before Parliament, is it reverses all of that. It says that these people who became owners under ULTRA are in fact not owners, and what they have to do is they have to apply to the minister to become owners. Now, this is a strange thing because the minister is going to truly seriously consider perhaps 4, 5, 6 million applications. They have to be published in the Gazette, there have to be opportunities for objection, there will have to be red tape and procedure. In reality, of course, this will be done by lowly petty officials throughout the country, and in reality it will create an extraordinary, spectacular opportunity for corruption, abuse, victimization. So why did the government do this? Why did the Constitutional Court say that it should be done? We're going to get to that, but first some of the history. The Free Market Foundation is South Africa's leading organization and has probably the greatest expertise in South Africa on land ownership, land tenure, land history. Since the 1960s, I personally, before there was a Free Market Foundation, have been an activist for land ownership by black people and abolition of apartheid discriminatory land ownership under the Natives Land Act, the Group Areas Act, and many more, the Black Areas Administration Act, and so on. So that goes, we go back a very long way together. Now, titling in South Africa has been an incremental process. Greater and longer leases were being issued to black people, all sorts of forms of tenure and permissions to occupy and deeds of grant and quit rents and many others, about 100 different types of tenure and title were being created in South Africa, which each took it one step closer to full ownership. Ultra was the final step that said, that's behind us now. All of these multiple variations of discriminatory apartheid tenure are abolished, and the black people who are the registered holders of land simply become owners, provided that land is proclaimed in such a way that it can be registered in the deeds registry. So the Market Foundation project, meaning My Home. The Kailam or My Home project sets about registering ownership of land in the name of black people, full unambiguous ownership, no more of this restrictive, racist, discriminatory stuff, including, for example, RDP houses, in which black people become theoretically the owners, but in practice they're subject to an 8-year preemptive clause, which basically means they aren't the owners until they have been there personally occupying for 8 years. Then they become the owner. In reality, most of those people sell and trade and move, and so that when the 8 years expires, all sorts of people, millions of people in South Africa, are, according to the government, the owners of land, but in reality they aren't. They've long since disappeared and someone else is the occupier of the land. So the Kailam project wants to correct all of that, wants to get full unambiguous ownership for all black South Africans, exactly equal to the ownership white people have and have always had, and black people who are buying now in historically white suburbs or leafy suburbs get full ownership, which they are free to trade and let and mortgage and develop and subdivide and consolidate and so on. So that is what Kailam is setting about to bring about in South Africa, a true end to apartheid land law and rights. Kailam has been instrumental to an unknown and unclear number, but probably something like 10,000 properties, and it depends on when you count from, and it depends on where you count, and it depends on how you consider Kailam's role to be in direct creation of full titles. But a round number for now, 10,000 will do. But many, many thousands have been the result of Kailam because of indirect transfer. Municipalities, local governments, for example, in Alexandra Township, where Kailam set about trying to get title deeds restored to black South Africans in something like 3,000 homes there. The Johannesburg City Council, largely or partly in response to the Free Market Foundation's Kailam work, is now issuing title deeds, and a few thousand or a few hundred have now been issued. Eventually 2,000 to 3,000 will be issued. So the indirect number is probably, nobody knows, but it's certainly tens of thousands, if not hundreds of thousands. Then there are probably about 1 million limited titles in various forms in South Africa, and 5 million lie ahead. In other words, where must this go? What should happen in the future? And this is an interesting question, is how many will there be? Now, the government in its own submission to Parliament says it actually has no idea how many people are entitled to land or have land, acquired land and ultra, and therefore how many people, if the amendment goes through, will have to apply to the minister. It simply doesn't know. And when it was asked by the Parliamentary Portfolio Committee if the department had the capacity to handle the number it didn't know, it said it didn't know. So it simply is a strange law that will place into government a function which it doesn't itself understand. Now, we're talking about the homes of maybe 20 million South Africans, and we're talking about land probably and housing probably worth well over 1 trillion rand, or roughly equal to an annual South African government budget. This is, in other words, a massive act of empowerment, of land redistribution, of land titling, of transfer, of the abolition of apartheid, and that is why I say it is probably the single most important law in South Africa, second only to the Constitution. If there is another law that is more important, it gives black people more rights, redistributes more wealth, then I would like to know about it. I don't know of such a law. This is the typical home that black people occupy in South Africa and to which ULTRA applies. ULTRA says that these houses now belong to and are owned by the people who occupy them, and at any time any of them can go and get a title deed issued that says that, but it is not a transfer. The conversion took place directly under the Act as the Constitutional Court held. This is what tends to happen after people get title. This is a before and after of the same house. You can see on the day that the title deeds were being issued, bricks were waiting and stacked outside ready to improve the home. And this is what happens when people walk into a free market foundation or KLM titling ceremony as tenants and walk out as owners. This is the effect on people becoming owners of land that were previously simply occupiers of land belonging to the government under apartheid. So ULTRA upgraded the land directly. It didn't require any further act in order to become owners. It converts so-called Schedule 1 land to full ownership. The Act does that, as the government said in its submission to Parliament, and it says in its various documents. So how it can now set about an amendment that will take away all that land, which is really obnoxious and bizarre, is not clear. But it believes that this is compliant with the Constitutional Court judgment. In my view, it's not what the Constitutional Court ordered, and the government has misunderstood and misinterpreted the order, which I will get to. So Schedule 1 refers to essentially proclaimed areas or proclaimed townships. In the old days, they used to be called locations, or largely or historically black areas. There are many confusing ways, and none of them are precise, of referring to the land concerned. But nonetheless, it's land for which there is technically a township register. As I said, that means something that can be registered in the deeds registry. And then it says that such land shall at the commencement be converted into ownership. In other words, once the Act is brought into effect by the proclamation by the then President, then the conversion occurs. That is what brings about the conversion to full ownership, and that is clear under the Act. Titles reflect but do not create ownership. In other words, the idea then that we and KLM and the Free Market Foundation do is to get the land people, in our view, that they already own. It is their land. And what we do is we then have the title deed issued to say it's their land, and therefore they do not pay. The government doesn't get paid. The local government doesn't get paid. We have to go around and persuade local governments that it is the people's land. There is nothing to be paid. They're not giving them anything. They're not beneficiaries. They are simply people getting a title deed that describes what they already have. The department evidence to Parliament, the Portfolio Committee, the Department of Land Affairs, basically says that they do not know how much gender discrimination is. The Constitutional Court handled one case, the Ruby case, and there was another case in KZN, which is not particularly the important one here. And this case was one in which a sister who had lived in a home, maintained the home, upgraded the home for, I forget the exact period, but let's say 25 years or so. The land, because it was in a former Bantustan or homeland, or Botswana, could be granted only under what was called a deed of grant at the time. Very odd word that originally came from the Cape Colony, but we can't go into that sort of detail now. That it was granted to the eldest son under racist apartheid laws, and she claimed that she was the actual one who should have been entitled to it because she lived there and maintained the place and was primarily responsible and not her brother. The Constitutional Court upheld her case and said this was a case of racial discrimination, unconstitutional under Section 9(1) of the Constitution, which says everyone is entitled to equal protection of the law. And that is a correct judgment. I don't think anyone could argue with that, although there is a technical argument maybe, is whether the Bill of Rights makes historical corrections. In other words, some discrimination that did occur in the past. This is a kind of new idea. Typically, it's been assumed by the Constitutional Court that that the Bill of Rights and the Equality Clause govern the future and don't change the past. Anyway, this does change the past. That is a very interesting judgment, and I personally have no objection to that. But then the Constitutional Court case before Parliament with a proposed amendment, the departmental representatives were asked, how many gender discrimination cases do they think there will be? They have no idea. The only people who have any idea are actually us, because we are the only people who've been registering real title deeds. So we can speak to that question. We know how many cases might arise. But the government has no idea, the Constitutional Court has no idea, Parliament has no idea, the department has no idea, and so there is now this very, very far-reaching law of the expropriation without compensation of an unknown number, perhaps 4 million black South African properties of low-income, poor black South Africans who acquired land after apartheid, whose land is now taken away if this bill goes through, and they will have to start applying for it. And this is all because there might be gender discrimination, but nobody knows how much. So one single case proven, and maybe one or two others, or maybe 10, maybe 100 other cases that can be shown to have been victims of gender discrimination. In order to fix that, this is cracking a nut with a sledgehammer, that you don't need to bring about this extraordinarily extreme, far-reaching amendment, not required by the court, but proposed in the bill because of that. So now the question is how many properties. The department said they don't know. They don't know how many people are affected. They don't know where the properties are. They don't know what the values of the property are. In other words, we have a bill here where nobody knows what they're doing or why the bill is being passed. We have some idea, and our view is it's a great mistake. They have no idea whether they have the administrative capacity. They have no idea what will be required of them, or what the cost will be, or how long it will take, or for how many years or decades or centuries. They have no timetable. In other words, over what period will this new proposed amendment be implemented. They have no socio-economic impact assessment. There is apparently a draft one in the department, but it's not been published. So we have no idea what they think, if they have thoughts on this at all, if they have predictions. But it's not known. Now, the Ruhubi judgment was the sister against the brother, and the sister, Henshrine Ruhubi, won the case and had the property allocation or registration under Ultra in her brother's name reversed. And that's perfectly in order. That's fine. That is actually how you should do these things, is bring a discrimination case to court and have a misallocation or misregistration of property corrected. It was in the former Botswana, now in Tshwane, and under that law only men could acquire property. So the sister lived, maintained and improved the property, and yet the man became the owner. So what's the government's solution to this problem? Well, what is proposed by the department is an amendment which expropriates without compensation 4 million black, low-income, poor people, South African homes, which is an extraordinary act of dispossession, bigger than anything that ever happened under apartheid, bigger than anything anyone envisaged under expropriation without compensation, a few hundred or thousand farms maybe, maybe some other properties. But this is a giant act of expropriating the very poorest of South Africans and putting them precisely back where they were under apartheid. Under Verwoerd's apartheid land laws, black South Africans could apply to the minister to become an owner, and some did in what became known as black spots, where black people had full freehold title. So this is now going back to apartheid. This takes us back to 1960s, 1970s apartheid, the depths of apartheid, the very worst form. And how could our parliament 25 years after apartheid be considering something so extraordinary, so completely grotesque? That there will be discretionary power. It will be costly to implement. It will be slow, and there's no known delay. What will happen? People will have to make an application to the minister. Millions of people. Obviously, the minister wouldn't personally become involved. This will in practice be done by lowly officials. And And then this will be discretionary. Now, the discretionary power, you can imagine, you give some government departmental official the right to decide whether you or someone else becomes an owner. They publish some advertisement in the Gazette, which nobody will see, so the point about that is a bit superfluous. It would be much better if it's done at local government level, with publishing at local government level and mentioning on radios that title deeds are being issued, and anyone who has any dispute or debate can come to them. We in the Free Market Foundation provide all of the local governments with dispute resolution mechanisms precisely to handle any dispute that might arise between government officials, between brothers and sisters, mothers and fathers, parents and children. Siblings are all people who might have disputes as to who should be getting the title deed. And we in the Free Market Foundation have handled such disputes. We're the only people who have dealt with land ownership and conversion disputes. And we can say very, very good news. All of them are very easily resolved, we've done about 3,000 properties. Something like a dozen disputes arose. Of those, all except 3 were resolved before appearing at a hearing, of which I was the chair in the Bakhatla Bamotsha tribal or traditional area. And the other final 3, when they were sitting in the waiting room, came in and said they had solved the problem as well. So we actually had to do 0 dispute resolutions. That is how rare it is. The FMF solution is different, that it should be dealt with and handled as it now is at local government level, and local governments can have a dispute mechanism and a publication mechanism inviting people to raise disputes. This is the right place to do it. It is the place at which it is presently done, and it's where it's done actually very well, and the Constitutional Court was not informed of any of this simply because they didn't ask us, and we were the only people who could give them that information. The cases are very rare, and it arises, for example, in RDPs. Now let me point that out. It's not particularly a gender matter with the Reconstruction and Development Home, but what it is that the property is allocated by the government to a so-called owner, subject to this 8-year preemptive clause, and then that property is sold, traded, bought to somebody. So when the preemptive clause expires 8 years later, the person who thinks they are the owner of the property is not the one who's registered as such, and there can be a dispute. The original owner could come back and say, no, I'm really the owner. How often does this happen with something like 4 or 5 million RDP homes? And the answer is almost never. That is why this extraordinary potential problem nightmare of RDP preemptive clauses has not become a big issue yet, because people don't realize yet that there are going to be, most of these RDP homes will be technically, according to the government, owned by A, but according to the people in the community and the people in the home, by B, or C, or D, or E, or F, as it trades through a daisy chain of transactions. This is a typical photograph of one of our titling ceremonies. The audience, these are the people waiting to get their title deeds. And the interesting thing is the Constitutional Court was told and believed that ultra brings about discrimination against women. Well, I've used one of the only close-up shots we have, simply so you can see for yourself what the gender mixes of the people about to get title deeds, and we are the only people who know, that it's actually roughly 50-50 throughout the country, in some areas overwhelmingly men, other areas overwhelmingly women, but that's not something that concerns us. We just register the deed in the name of the current registered holder. So the idea that there is gender discrimination is simply wrong. It is not what has in fact happened under Ultra and what is happening now in the issue of title deeds. That is an audience in Ngwate, which most people might know as Parys, Northern Free State, and this is the standard sort of audience we have. And I say an audience, these are the people, those people you see in that picture, walk in as tenants of government land and walk out as owners of their own land. And it becomes very emotional. Sometimes we're all in tears. This, for example, is Miriam Matupi, who was at the time 99, now she's whatever, 102 or 103. And she was the one who wept when she was handled her title deed. And when asked why, and she's now in the home, sitting there in the home she now owns, And she said words to the effect that now I'm finally, I can die with dignity, that I've lived in this house for 50 years. Finally, I'm the owner. I've never had security. I've never considered it mine. I now have something to leave to my grandchildren, and this is one of the most important moments in her life. She was in tears, as we all were too. This is a woman who is 101 years old and also in front of the house in which she's just recently received her title deed. And this is the sort of person who is becoming an owner. Finally, as Ultra got rid of apartheid, and now you have a bill before Parliament that will take away all of this ownership, all of these rights of people who are finally experiencing and enjoying human dignity and racial equality and gender equality. The Ultra Amendment implications are that the Department admits that there is no discrimination in the law itself. It says anyone can listen to the proceedings of the Parliamentary Portfolio Committee and hear what the government officials have to say, and they say the Act itself has no racial discrimination, yet the Constitutional Court says they have to amend the Act in order to make it not discriminatory, which is a very strange judgment, I have to say, and I think it's probably because all the people involved didn't really understand much of what was going on and didn't really understand the implications. The discrimination might have arisen under some historic law, the Black Areas Administration Act or whatever, and so that the property is now, the registered holder might now be a man, not a woman, but that doesn't mean that the Act itself discriminates. If you want to fix the racial discrimination of the past, that's what you address. You don't have to amend the Act. And the Constitutional Court didn't say how the Act must be amended. We would recommend an amendment that brings about the actual effect desired. In other words, that says that if any discrimination can be found, racial, gender, or otherwise, that discrimination needs to be fixed. In other words, declare that the registration mustn't have discrimination, not that the Act mustn't have discrimination, which according to the government it doesn't. So why was the judgment? And it's not clear that the Constitutional Court understood the issue at all, understood the magnitude of the issue, the commonality of the issue, or that this applies only to a few old Bantustan properties, and there are not many ones that had deeds of grant issued or leasehold titles issued in the old apartheid South Africa. Botswana was one of them, Ciskei was another, but mostly a few in KZN. But in most of South Africa this never happened, so it is not actually a problem. The real issue arises in the Sowetos and Katlehongs and Longas of South Africa, the so-called old locations or towns, what we now call townships. That is where you have people who have not been discriminated against, at least not officially, not legally, not in law. There was no law saying that the property needs to go only to men or women. There was under the Group Areas Act Section 10, for example, a preference in favour of men, and this did result in some discrimination, and if that can be shown, it should be fixed. Then, in order to satisfy the Constitutional Court, the requirement of a discretionary application has obviously unintended consequences. I don't like the term unintended consequences because I think we should say that consequences of a measure are intended. There's no reason why they should not know what the consequence will be, and we should drop this term unintended consequences. We should call consequences intentional. For example, the unemployment created by labour law should not be considered an unintended consequence of the law. It should be considered an intended and desired consequence. So this is a consequence that is desired by the parliamentary amendment, not the Constitutional Court, in trying to satisfy the Constitutional Court. There will be enormous costs and delays and uncertainty. There will be bribery, corruption, victimization on an unprecedented scale that will make the Zondo Commission look like the Mother Teresa Commission. This is just asking for it. The department admits that there is no discrimination in the Act. The past should remain as it was. Now this is interesting. It says that the registration titles that have been issued so far should not be affected. There's a bit of a qualification which is technical, but for practical purposes, that it leaves what was done in the past unaffected. Now, my own view is that's actually not consistent with the Constitutional Court judgment, which says that that's not allowed. So the amendment bill does not actually achieve what the judgment requires. And then it says people who have not yet been given their title deed will lose their property. Well, that is expropriation without compensation. It's a violation of millions of black South African people. It's quite extraordinary to say that what they have not, those who have not gone through the tedium and the cost of registering a title deed lose their land simply because they haven't done that. That's a very strange thing to do. Then what you could say is that it won't apply to the future. In other words, properties that in the future become registered townships or have township registers opened, they can be subject to an application process, although I would be against that too. I think black people we should stop having an idea that black people occupy and live under land under something different. It should just be the same. There should be one form of recognition. So that brings me really to the end of my presentation. This is Miriam Batupi, our favorite person. There are some details that I could go through of the Act if it arises in question, but I will discuss this one quickly after my technically completed presentation. And that is Section 2.1 of the Ultra is declared by the Constitutional Court to be invalid insofar as it automatically converted holders of any deed of grant. Now remember, this is not a lease in a township like Soweto, but this is a thing called a deed of grant, which was a very specific and actually in recent South African history quite rare. It was very common in the old colonial times. And a right to leasehold. Now this is a registered leasehold. As defined in the administration, this is called Proclamation 293, the Control of Townships in Black Areas Proclamation of 1962. In those days, laws for black people were made by the President issuing a proclamation, not by an Act of Parliament or a bill, or even normal regulations. So to the extent that it violates women's rights under Section 1.9 of the Constitution, which says everyone is entitled to equal protection, to the extent that it's a deed of grant under that Proclamation 293, that is what the Constitutional Court requires to be fixed. What the bill does is remove all the properties regardless of whether they comply with what the court actually said. And so there is not a compliance with the Constitutional Court order. In many ways, one is it doesn't fix the past discrimination as the court wanted. It doesn't apply to all ultra land as the law does. And yet the amendment removes all ownership and does not fix racial, gender, age, other discriminations of the past. So we are of the view that the bill should be scrapped. It should go back to the drawing board. The Constitutional Court gave 18 months for it to be fixed. We would happily recommend an actual practical way of fixing it. Thank you for your attention, and I hope I've clarified what is going on, what Ultra says, why it might be the most important law in South African history, and what the amendment says, and why it might be the biggest act of expropriation without compensation in South Africa's past or future. Thank you.
Thank you, Leon. That's an extraordinary presentation and raises so many questions, and we're getting questions in from people who are listening and watching. But in effect, you're saying that this extreme bill, which will have extreme consequences for you say 4 million black people in South Africa, is not necessary at all and should not happen.
No.
It's due to a misunderstanding.
It's a misunderstanding by the court of the problem, and then a bigger and much more serious misunderstanding. And that's simply because of the evidence led to the court. I'm not defaming the court here. The court simply was given misleading evidence of gender discrimination and thought that this required an amendment which would not achieve what the court wants. But nonetheless, the real problem, the real travesty, is how the department has responded to the court's judgment. And it has responded by essentially declaring all of the property owned by black South Africans in townships to no longer be owned by them. And when I say 4 million, nobody has any idea. That is my, let's say, informed or educated guess, which I think is as well as informed as anyone's might be. So in other words, if they want to know how many, they should come and talk to us in Kyle and the Free Market Foundation.
And so the fault lay with the department, the drafters of the bill, who put the wrong information before the court.
Yes. Firstly, the bill that they have before the Parliament does not fulfill the court's order, and it also goes well beyond the court's order, which is that land held in an essentially historically Proclamation 293 homeland under one of two types of title, a deed of grant or a right to leasehold. And to the extent that that violates women's rights under Section 19 of the Constitution, that is all the court required to be fixed. And it should then say so. It should say that in such land as the court ordered, that in transactions that violate women's rights, the Act does not apply, and then say what will apply, and then you can say some dispute resolution mechanism or administrative process or advertising process will take place in those cases where women's rights have been violated. You don't have to abolish the entire empowerment and entitlement of black South Africans in order to achieve what the court wants.
Surely why are they pressing ahead with this if that is going to be the consequence, the intended consequence? Surely this has now been recognised?
I don't lightly say this, but I think this is an area and an issue on which those involved truly don't really know what they're doing. And it's not their fault. It's because this Act just was never implemented. No one's ever heard of it. It's the most important law in South Africa. And this is their attempt to fix it. The court's attempt, the departmental attempt, but they have they have proposed this bill out of all I can imagine is misconception and ignorance. They're just confused. I would like to sit down with them and have a chat to them. I am seeking, by the way, meetings with two of the ministers, the two ministers involved, Minister for Local Government and Land, and I fully expect those ministers to actually have no idea what the implications are of these bills. They assume that the work has been properly done. It's very clear, anybody can listen to the audio versions of the evidence to the Parliamentary Portfolio Committee by the departmental officials, and they will see that they themselves admit that they actually have no idea what's going on, how much discrimination there is, how many people are involved, or, what the implications of this amendment will be. They simply have no idea, although they supposedly have a draft socio-economic impact assessment which would clarify all of that, but nobody outside of their departmental officials have seen it.
But isn't the socio-economic impact assessment supposed to go with the bill?
Yes, they were asked by the Portfolio Committee, where is the socio-economic impact assessment? There must be one. And the department said, sorry, you don't have it yet, we're still working on it. Now, what work will they do on it? Well, we know that they have already admitted that they have no idea what the implications or the numbers or the values involved are. And they have no idea how many gender discrimination, how many violations of women's rights, to use the Constitutional Court terminology, there might have been or might be in the future. And if there have been in the past, this bill says no, they're not going to be corrected. Now, that's not what the Constitutional Court said. They must be fixed if there's historic gender discrimination. And so to reinforce what's been done unconstitutionally in the past, abolish what has been done constitutionally, is certainly not the way to respond to a relatively, well, for the people involved, a big problem, obviously, gender discrimination, but numerically in South Africa, a very small problem.
Thank you. Given that land is such a big issue in South Africa today, expropriation without compensation, land reform, why have so few people heard of Ultra? Why has it flown under the radar all this time if it's been around since 1991?
Yeah, I speculate, why this bill in this strange form, why the judgment, all one can do is try and guess, and I'm sure there are people who have better information than me. All I can think of is that having been passed in 1991, one of the first acts in the transitional years, where there were negotiations taking place and where the then government had agreed to convert all land to ownership and thereby end land apartheid. But because everything was focused on CODESA and the constitution and the transitional process and the release of Mandela and F.W. de Klerk having TV debates and so on and so forth, people just didn't notice this act. It just somehow was passed and lost in the cacophony of transition. And then there was a pilot attempt to implement it in something like I forget the exact date, 1994 or so. But then nothing more. Essentially it was never used or implemented. But because we were part of it, we brought it to the attention, for example, of the deeds registry, of the Department of Lawyers. We would go to lawyers and say, we want to register land under Ultra, and they would say, we didn't find a single law firm who had ever heard of it, who knew it exists. And so it just was a very strange thing, a completely forgotten law, and yet probably the most important law in our history, apart from the Constitution itself, which then dominated all media coverage and everybody's attention.
I must say the questions that are coming in and the comments that are coming in are just expressing astonishment that this bill is before Parliament when people recognise that it's the wrong bill, it's the wrong way of dealing with this, and yet it still seems to be going ahead.
Yes.
Many of the questions and we're getting comments are reflecting this.
Yes, they're absolutely right. It is astonishing, and one has to be dignified in comment on these things. There are very, very bright people involved, very well-informed lawyers and politicians and officials and judges, and so one has to acknowledge this. But it is astonishing that there does seem to be a complete misconception from beginning to end of what Ultra is, what it was intended to achieve, what it has achieved. It has turned all of these people into, they are owners. This is the part that seems to have been lost on the court and the department. And it is absolutely astonishing, and everyone should be astonished. And this should be a big media event. I don't know, the media needs to pick this up and say, what on earth is going on here? This ought to be the biggest media feeding frenzy, since the Constitution.
Well, I hope all you journalists out there listening have taken on board what Leon has said. This is a very, very important issue which has been dropped, and we do need to make more of it in your publications. Just going back to the original bill itself, why hasn't the government implemented Ultra? Why has it been only Kai Lam which has brought this into the fore?
As a result of Kai Lam's work, the government now has a program which it's working on, and we have no idea how many it's done, but there are various attempts, the Johannesburg City Council, the department itself, the KZN government, there are various areas of government in which the bill, since we drew attention to it and made it recognized and known, the Ultra Act is being used and black people are being issued their title deeds. And that's very good. So the government has picked it up, is doing it, but it's still on a very, very small scale. In other words, we're talking about maybe tens of thousands. If we're lucky, let's say 100,000, 150,000, maybe more, nobody knows. The government doesn't know, the City Council of Johannesburg doesn't know how many it has done. It's an extraordinary area of complete lack information, where there's just no information. Nobody has any idea what's going on anywhere. And these land audits, for example, that say how much land is owned by white and black people, they just ignore all land under Ultra. It's as if they don't know it exists, as if it's invisible. So all we can say is that hopefully when we bring to their attention what I've covered in this address, they will go back to the drawing boards and fix what is a very, very serious and conspicuous series of errors and misinformation that have led to this situation, starting with the non-application and implementation of ULTRA in the first place, and ending now with a bill that would effectively abolish what ULTRA achieved. The first and most important and big joint law in the transitional period in South Africa, if this bill goes ahead, will be reversed, and we will be right back to where we were in the darkest days of apartheid.
It hasn't been understood. Several people are asking a very important question, and that is, how would the Section 25 of the Constitution proposed amendment affect ULTRA, or would it affect the amendment bill? How do the two play in together?
Yes, under the existing Section 25, this bill is probably unconstitutional. In other words, the biggest victims of repealing or amending Section 25 of the Constitution will ironically and paradoxically be poor black South Africans, not rich white farmers or rich people with houses in Llandudno or Constantia or somewhere, but it will be the poor. It will be the millions of poor people, and this is exactly that. If the Section 25 is repealed, then it will render this bill lawful, constitutional. Under the existing Section 25, the proposed amendment will be unconstitutional. And that is one of the reasons why Section 25 should not be changed. You know, many people continue to debate Section 25 and expropriation without compensation. That's not what I'm here to talk about, but I do need to make this passing comment. As a white versus black thing, that this is going to take white land and somehow redistribute it to black people, this is completely mistaken. By far the overwhelming majority of victims by value and number will be black South Africans. Not only do we see this now under this ULTRA amendment, but the first expropriation without compensation announced in South Africa was by the Ekurhuleni government for the informal settlement of Marathon and Delport. And they said as soon as the amendment goes through, as soon as the Section 25 is abolished, they are going to expropriate without compensation the entire Marathon and Delport informal settlement, one of the poorest and one of the biggest in South Africa. And so they will render homeless, now in informal homes, nobody really knows the number, but we're probably talking about 30 or 40,000 people. So these are going to be the victims. The victims are not going to be some rich person who can defend themselves and go to court, or some big company or some commercial farmer. The victims are going to be poor people who are defenseless. And the government has now done this at least twice. One is Ekurhuleni, one is the ULTRA Act. And this is one of the paradoxes. This has to be deracialized. We have to stop seeing expropriation without compensation as somehow black versus white, as the protection of white privilege. No, it is the protection of black victims of apartheid, which Section 25 achieves. And it says that nobody may be deprived of property without due process of law and without compensation. This ULTRA amendment proposes exactly that. It directly violates Section 25 of the Constitution and sets about expropriating without compensation.
Just a reminder, on the invitation you received, there is a cell phone number to send WhatsApp questions. Please keep them coming through. Some very interesting ones coming in. So, Leon, what can black people do? What can black landholders do to secure their land rights? What should they be doing? What advice would you give them?
Well, the first advice is get a title deed quickly, because this amendment says if you've already got one, it's going to stand. So before this bill gets passed, if it's going to be passed, get a title deed issued. In other words, flood the deeds registry and the local governments and the Department of Land Affairs with thousands or millions of applications for title deeds. But of course, most people won't even know that they're entitled to the title deed. No, most people are relatively uninformed, low income, people without resources and sophistication. The next thing is that if they can work through their political parties, their political structures in the ANC, outside the ANC, in IFP, DA, UDM, whoever it might be, the new parties that are being formed by Herman Mashaba, for example, work through them to bring to the attention of politicians, the public, the media, that this travesty is about to take place and must be stopped. The next thing to do would be to establish to what extent there really is a problem. How many people have this gender problem? And I would add that it's not just a gender problem. It is a problem between siblings. It is a problem between generations. Who does and doesn't become the registered recipient of the title deed? That's a tough question, and it needs to be answered, and that is why we have a dispute resolution mechanism. It doesn't refer to gender. It just says if there is any dispute regarding who should become the registered owner, then that dispute must be resolved at local government level. And the way that it will be typically resolved is the person who is the registered holder will become the title deed holder, and the person who legitimately disputes it will get another piece of government property, an RDP house or another piece of land. So it's really simple to solve. It's very small numbers, and it's not got the gravitas or the importance that it is so far been presumed to have.
I believe that the public consultation period has closed, or the deadline for submissions has actually ended. But what you're saying is people can still make their feelings heard, they can still protest. There's still scope to have this bill stopped.
Yes, through political parties, through Parliament. There still have to be portfolio committee hearings. This is a draft bill. Before it gets formally tabled, there's a lot that can be done. If submissions are sent to the government right now after the deadline, depends on who they come from. If it comes from someone important like COSATU or business leadership or someone like that, the government will probably look at it anyway and take it into account. But if it comes from ordinary NGOs and people like us, they probably would regard it as closed. However, there are politicians, there are journalists, there's public pressure can be brought, the climate of opinion can be changed, and I hope that there are media people out there who see in this probably one of the biggest, potentially biggest and most important media events I can think of. This should be headline news and headline debate, and there should be TV debates and TV discussions, and you can change the climate of opinion, influence government policy in ways other than making a formal submission, which in any event is done usually by very, very few people. I don't know how many submissions there were in this case, but I would be surprised if the Portfolio Committee had more than 10 or maybe 20. There are 50 or 60 million South Africans. There are 4 or 5 or 6 million homeowners who are affected. They obviously do not make submissions, and the government doesn't talk to them. It sometimes has hearings around the country. It said it couldn't because of the COVID thing, so the department even apologized to Parliament that there hasn't been a normal consultation process, and expressed concern that the lack of a normal process might render the bill unconstitutional because it's required by the Constitution, Section 195. So we're sitting here, strangely enough, and where an attempt to comply with the Constitution may itself be unconstitutional because there hasn't been a public consultation process.
Thank you. So there's a lot that can still be done by the media and the public and other interested parties before this bill becomes law, if indeed it does. Just moving on, you talked about Kyle in your presentation. Can you explain to us a little bit more about how the Free Market Foundation and Kyle is using the Ultra Bill?
Yes, Kyle is wonderful. It's our biggest project. It's run by amazing people, mainly Perry Feldman and Veronica, his wife, and people in the Free Market Foundation, my colleagues, and it's funded. What basically Kyle does is it tries to convert land already held by black South Africans, and nobody knows how much that is. I've had estimates of everything from 5 to 10 million properties that are held, some of them, about 4 million maybe, in what are called registered or proclaimed township areas, and the rest are, in semi or informal, semi-formal, in traditional tribal areas, or what they call, wrongly, by the way, in the parliamentary discussion, communal land. It's not communal, it's individual, and it's just not titled. But nonetheless, all of this land should be, is under consideration. Sorry, I think I kind of did. I interrupted myself. Have I answered the question?
Yes,
Yeah.
just to explain to the journalists.
Oh, Ka'alam, this is what Ka'alam is. No, I don't think I've done that adequately. Ka'alam sets about a meeting with mainly local governments, municipalities, and asking them if Ka'alam can come and do the deeds registration. And it's sponsored, it's subsidized by some big companies, by private individuals. We know, for example, of somebody who just does one a month by herself. We know of companies like Ringgrow and the Rupert's Reinhardt Foundation, which sponsor literally millions of rands worth and tens or hundreds of thousands of titles. And so anyone who is interested in helping us should go to the website, contribute to Ka'alam, make a donation, something like 2,500 to 3,000 rand, gets a title deed issued. There's no purchase price for the land. In other words, for 2,500 or 3,000 rand, somebody can become the owner of a 400, 500,000 rands value of land or housing. So Ka'alam works with many local governments around the country. I confess to not knowing how many it is by now, but let's say depending on the stage of consultation, the initial discussion, the actual registering and implementing of deeds, you're talking about 35 perhaps. Local governments and municipalities, mostly in the Western Cape, but all over the country, with all political parties. We are racially agnostic, we are politically agnostic. We work with any political party. We work in KZN with the Inkatha Freedom Party. We work with the DA in various places, and we work mostly because they have most municipalities with the ANC. So the Free Market Foundation has no political affiliation or bias. And so Ka'alam sets about issuing the deeds to people who own the land under Ultra. Ka'alam does other properties as well, but those are the easiest, the quickest, the cheapest, and the most effective ones to register because they are already owned, and all that's required is a title deed, the piece of paper that says so.
If there are any more questions, please send them through in the next minute or two. Otherwise, we will be drawing to a close. And I'd just like to say, well, thank you very much to you, Leon, for an extremely disturbing and comprehensive presentation of how important that this bill is, this amendment bill is, and the impact it will have on mainly poor black people in this country. And I hope the media have taken on board aspects which they will then follow up on. There will be a media release coming out this afternoon, and of course interviews are always available. Please contact the media office, myself and the media office at the Free Market Foundation. The numbers and emails are on the invitation you all received. Otherwise, thank you all very much for attending and for sending in excellent questions, and look forward to seeing you again. Thank you.